The question is that the bill be now read a second time. Richard Bergen.
Thank you, Madam Deputy Speaker, and I beg to move the reasoned amendments on the order paper. Regulation of financial services has been discussed at length and legislated upon in this House since the financial crash, with the Financial Services Act 2012 and Financial Services Banking Reform Act 2013 being passed, and the Bank of England and Financial Services Bill now being brought to this House. And this bill is made up of two parts. Firstly, amendments to the structures of the Bank of England, and secondly, regulation of financial services. Now, we believe the Bank of England should carry out its work in the most efficient way possible, with transparency and accountability in its decision-making, serving the interests of the people who sent us here to represent them. We also believe that senior bankers and others in the financial sector should be effectively and appropriately regulated in order to deliver a banking culture that is free from the systematic greed and reckless risk-taking that precipitated a bankers' crisis of historic proportions in 2008. I'll give way.
Thank you very much. Is it not the case, though, that it was Labour who rescued the banks in 2008, and now it's the Conservatives who are selling off the RBS shares at a loss to the taxpayer?
13 billion. I thank my honourable friend for her intervention. She is quite correct, and what it does show is what disregard that the Chancellor has for the taxpayers' coffers for the public purse, which I think he's showing as well in relation to his numerous meetings and their shoddy outcome with Google. But financial stability and the effective regulation of our banking and wider financial services industry are vital in order that the sector serves the interests of the whole economy, doesn't hurt ordinary people or small and medium-sized businesses, and delivers vital investment our country needs for long-term growth. Getting the balance of regulation right is an important task for any government. This is a task which governments around the world have failed to fulfil in the last decade, a task which has been attempted since the bankers' crisis of 2008. But, however, it's a task which today the government threatens to set back. Madam Deputy Speaker, the context of this bill is vital to understanding our concerns on this side of the House and the very reasonable concerns and demands of the public. We are now 8 years on from the economic crisis, the bankers' crisis, that brought the financial services sector and the country to its knees and saw banks too big to fail bailed out by the state. I will give way.
Of course, the honourable gentleman. He wasn't here then, so he can form a dispassionate view. What has he learnt about the mistakes that the regulators made under Labour when we saw all those excesses he's now talking about?
Lack of regulation.
I thank the honourable member for his intervention. At the time, Conservative members were calling for even lighter regulation. But what is clear, and what I will illustrate, is that on this side of the House, the lessons of the banking crisis have been learnt. But this bill shows that the lessons of the banking crisis haven't been learnt on this side of the House. So 8 years later, and bankers' behaviour and bankers' bonuses remain in the news. Court cases and institutional fines continue, with hundreds of millions of pounds issued in fines, but still only one person in prison despite all the damage done. And despite a series of commissions and a series of reviews, there remains too little evidence that the lessons of the bankers' crisis have been learned. We should all know that the public remain angry at what a number of top bankers did to our economy and to our society. I'll give way to my honourable friend.
I thank my honourable for giving way, and he's making an excellent speech, with which I strongly agree. Was it not astonishing that before 2008, the banking sector, the private banking sector, didn't appear to spot the crisis that was coming? They were too busy making money hand over fist for themselves.
Some of us did.
Thank you, Madam Deputy Speaker, and I thank my honourable friend who has extensive experience in these matters, and it is rather troubling that the same people who now say there is no risk of a financial crisis ever again were the very same people in the very same sector that were saying before 2008 that everything was fine and there was no risk of disaster at the time. How wrong they were, sadly. But despite the entirely justified anger amongst the population about what the bankers did to our economy and to our society, the Chancellor has cunningly turned the bankers' crisis into a crisis of public spending, with a policy of spending cuts for vital services to which there seems to be no end in sight. And looking at this bill, it appears that the Chancellor believes he can now turn back the clock in the banking and financial sector. So under this Chancellor, things are going in the wrong direction. He has sold off shares in RBS at a very significant loss to the taxpayer. He appointed Angela Knight, who was head of the British Bankers Association during the financial crisis and defended the top bankers during the financial crisis, to head up the Office of Tax Simplification in the Treasury. And he decided he could do without the continued services of the respected Chief Executive of the Financial Conduct Authority, Martin Wheatley. We've been told by the Minister that Martin Wheatley's successor, who I'm sure the Chancellor is delighted has been appointed, is fine with the abolition of the reverse burden of proof. I wonder if Martin Wheatley, his prematurely departed predecessor, would have said the same. And the FCA's planned public review into banking culture has since been cancelled, and its investigation into the promotion of tax evasion by HSBC has been brought to a premature conclusion. And I know that we'll be hearing more about the FCA in another debate in this House this evening. And so now the Government presents the Bank of England and Financial Services Bill, originally drafted, according to the Chancellor at the Treasury Select Committee, to make changes to the Bank of England's structure. However, and this is a key concern, added to this bill is a major change to the regulation of senior bankers, undoing a key measure taken after the bankers' crisis in order to attempt to change senior bankers' conduct and deliver transparency and accountability in financial decision-making. I am talking, Madam Deputy Speaker, of the presumption of responsibility, or the so-called reverse burden of proof. But firstly, I wish to say we welcome the extension of the senior managers regime to senior managers across all regulated financial firms, but we do not accept the Government's case for ending the presumption of responsibility for the top managers in banking. The presumption of responsibility, as currently set out, applies to senior managers. It means that where there has been a regulatory contravention in an area for which they are responsible, in order to avoid being found guilty of misconduct, they will have to prove that they took reasonable steps to prevent that contravention. This bill removes that onus on senior bankers. The onus is entirely reasonable and entirely proportionate, and bitter experience tells the British people it's entirely necessary. Misconduct and misdemeanours in financial services are not merely a tale from history. In 2015, the FCA had to fine firms over £900 million, and then there's a LIBOR scandal, Forex fines, and the mis-selling of PPI to the value of up to £33 billion. I will give way.
At the conclusion of her speech, the Minister indicated that by voting against the second reading of this bill, members would be actually putting members of the public at risk from further bank abuses. Would he not agree that the point that he is making here shows that by voting against this bill and getting a change so the reverse burden of proof is put back in place, that we are actually safeguarding against the abuses of the past?
Thank you, Madam Deputy Speaker, and I thank my honourable friend for putting this necessary point so powerfully. People outside this place will be shocked to hear that as a result of this bill, senior bankers in the top firms will have less guards on their personal responsibility. I do wish to make some progress now. Give way. I will give way. I'll give way.
Thank the honourable gentleman for giving way, but further to that point, the measures that he seems to object to so much are clause 22 of this bill. So why is he voting against second reading when there are all these other really excellent measures that he presumably does not object to?
Thank you, Madam Deputy Speaker. It may be that others can explain to her the real purpose of a reasoned amendment in these circumstances. I think it's entirely the right thing to do. The presumption of responsibility is so reasonable and necessary, in fact, that the policy was introduced with cross-party support. That shouldn't be forgotten. It was originally proposed by the Parliamentary Commission on Banking Standards, led by the Honourable Member for Chichester from the party opposite and Lord McFall of Acclwith of the Labour Party. And it was the Liberal Democrats, Lord Newby, a minister in the Conservative Liberal Democrat coalition, who moved its introduction into law. And I have to echo a point previously made by the Honourable Member sitting on the front bench, that it was passed as recently as December 2013, and the presumption of responsibility has yet to come into effect. It was meant to come into effect in March this year, and it remains untested. We must remember that this was a safeguard brought in by the very same Chancellor who is now seeking to scrap it, and I will give way.
To the honourable member for giving way. The presumption of responsibility hasn't gone. The senior managers regime absolutely has the presumption of responsibility for everybody working in these institutions, and he, as I have, may have had a number of conversations with some of these banks that are being affected by this. And actually, interestingly, and having been on the Banking Commission that brought in the reverse burden of proof, what has been interesting is that the banks are now complaining bitterly that the reverse burden of proof has now been reversed, because actually that managed to be a tick box operation, and now what they've got is a much more onerous responsibility for management than they ever had before. This actually is a far stronger measure of ensuring probity for the managers of banks than the reverse burden of proof.
Thank you, and I thank the Honourable Member who is experienced in these matters for his intervention. But every time we've received correspondence from bankers on this matter, every time we've listened to bankers on this matter, they seem desperate for the reverse burden of proof to be scrapped, and they were saying how dreadful it would be and how it was totally unjustified in their view, and business as usual is fine and we can just return to things and there's no risk of a repeat of the financial crisis of 2008 in their view. Unfortunately, I do believe they were wrong, but we need to remember that this presumption of responsibility, or the reverse burden of proof, was a safeguard brought in by the very same Chancellor who is now seeking to scrap it. And in 2013, the Chancellor said that he had called for a thorough and intensive investigation into how to improve standards in the banking system, and the Parliamentary Commission on Banking Standards has delivered. The Chancellor then announced that he was pleased to say that the government will implement its main recommendations. And of course, one of its main recommendations was this presumption of responsibility. And on that occasion, the Chancellor wasn't alone. This was his bill, and the members opposite backed it. Indeed, the Honourable Member for Tunbridge Wells from the party opposite, then Financial Secretary to the Treasury, clearly explained that his government was introducing new rules to promote higher standards for all bank staff. And he said as well that his government was reversing the burden of proof so that senior staff are held accountable for regulatory breaches within their areas of responsibility. So the Honourable Member for Macclesfield from the party opposite, who was briefly on the Treasury Committee, said as well, and I think it's worth noting this, that it is critical to bringing about the individual accountability that many of us want to see across our financial services sector, with the tough senior persons regime, reversing the burden of proof and criminal sanction to reckless misconduct. All those steps are vital. And his party colleague, the Honourable Member for North East Cambridge, said, "I do not think that there can be any doubt about the merits of reversing the burden of proof. The government's announcement that they will reverse the burden of proof is extremely welcome." And I could go on further, but instead I ask the question, Madam Deputy Speaker, what has changed? What or who has so dramatically changed the mind of the Chancellor? At the Treasury Committee in October, the Honourable Member for Wyre put the question many of us are thinking when he asked the Chancellor whether the proposed scrapping of the presumption of responsibility was, in his words, largely as a result of lobbying by the banks, which has the flavour of getting stronger.
My honourable friend give way on that point.
I will do.
I'm grateful, and I think it's an interesting argument that he's making in a very powerful speech. Would he agree with me? The Chancellor had said that he hadn't met with the banks in the lead-up to the general election, but apparently he's met with bankers on 5 separate occasions since the general election, presumably to discuss the contents of this bill. Is he concerned, like me, the Chancellor is the victim of Stockholm Syndrome and has become a prisoner of the bankers and their financial interests?
I thank my honourable friend for that intervention. Now, of course, it's correct that the Chancellor meets with senior bankers, but what does concern me and concerns many people outside this place is that the Chancellor appears to be acting in their interests alone. I will.
Thank you very much, Speaker. Following the comments by the Honourable Member for Newark, who told the media that the regulators and their political masters were captured by banking leaders in the run-up to the meltdown, is my honourable friend concerned that this bill shows the government are still being captured by banking leaders?
Richard Bergen.
Thank you, Madam Deputy Speaker. I thank my honourable friend for his intervention. And he hits upon a very important point. The role of a city minister, the role of a shadow city minister, and the role of the government is not to represent the interests of the city to the population, but it is to fulfil their democratic function. A government is not there to take the orders of the City of London. Yes, we must listen to the City of London and value its contribution, but we're not there as their political representatives on earth. So I will continue with my reflections upon the change of mind that the Chancellor has had, because indeed the Chair of the Treasury Select Committee put it very well indeed when he asked his Chancellor a very logical, sensible, reasonable question. He asked, why did you not wait for the regime to come into force to enable an assessment of it, how it works, before implementing this further change? It's a change based upon no evidence, Madam Deputy Speaker, and that's the worst kind of change possible. So that was a very serious question posed indeed. Now, of course, banks are having to put significant effort into identifying and establishing new procedures to meet the requirements of the 2013 bill. But when that bill was supported on a cross-party basis in Parliament, this was already abundantly clear. But now the Conservative government has dramatically U-turned and is not willing to even test the procedures it supported in the first place. It is rare indeed for an important measure to be abolished before it's even been introduced. So how will the public feel when they learn that the Chancellor is scrapping a duty on senior managers in banks, a duty that was welcomed as necessary on a cross-party basis before it has even been implemented? The public's deep concern that the behaviour of some senior bankers should extend to the Chancellor, who, it appears, is doing the bankers' bidding, not the bidding of the British people. Doesn't the Chancellor and doesn't this government understand the widespread anger and mistrust amongst the public when it comes to the banking system? The public are quite right to remember that because of the bankers' behaviour, people that this House is meant to represent lost their homes. Because of bankers' behaviour, people that this House is meant to represent lost their jobs. And we should not ever forget that it was the bankers' crisis that caused the deficit, which this government has relied upon as its justification for its political choice to cut our public services, to cut funding to our local authorities, to cut the incomes of working people and cut support to the most vulnerable people in our communities. I will give way.
Very grateful. He's been very generous with the time, but I'm sorry to be a bit of a pedant on this. But in 2005, there was a £43 billion budget deficit. There was a deficit long before the banking crisis, and there was a structural deficit which the banking crisis brought out.
Thank you, and I appreciate his pedantry. There was his words, but he makes a point which doesn't bear too much political scrutiny, if I can say that with respect, because it was the case that the global financial crash caused the huge increase in the deficit. It also, and this is the point, stalled and halted the economy, but it also gave the government the opportunity to have a reason to carry out its long-harboured ideological desire, decades old, to cut away the state and to cut public services and to wither away the state. But turning to the rest of the bill, Madam Deputy Speaker, this bill comes to us from the other place where there has been considerable debate at every stage, and the bill has changed following a number of amendments proposed by the government. In our reasoned amendments, we recognise those changes as improvements, and they are indeed welcome, but the bill has not changed significantly enough. As I mentioned, the bill is in two parts, and with regards to the first part of the bill, on the Bank of England structures, we do recognise some positive movement by the government, though it is insufficient. We recognise the government has moved on aspects of powers of oversight for members of the bank's Court of Directors, though their forum for discussion, the Oversight Committee, remains abolished. We recognise the government has moved on their proposed power of veto for the bank's Court of Directors over National Audit Office investigations, but a memorandum of understanding referred to in this bill remains under negotiation and remains unpublished. But in other aspects, in the House of Lords, in the other place, there was not agreement. I wrote to the Chancellor asking that the Memorandum of Understanding be presented to this House whilst this bill is making its passage through Parliament. And the Minister, I'm glad to say, has responded, explaining that the Memorandum of Understanding is not yet complete and is subject to ongoing discussions between the Bank and the National Audit Office. The Minister has explained that she will write to both the Governor of the Bank of England and the Controller and Auditor General at the National Audit Office to see if they will be in a position to share the draft Memorandum of Understanding during the passage of the bill. In the case of such an important matter as this, it can only be right for this House to have had sight of the crucial Memorandum of Understanding in question. Any other approach that transpires would be a cause of concern. The bill replaces the Prudential Regulation Authority with a new Prudential Regulation Committee, and peers of all sides, including those on the government side, expressed concern that this represented a downgrading and threatened loss of independence. And as I've already mentioned at length, Madam Deputy Speaker, the bill also replaces the presumption of responsibility with the duty of responsibility, and opposition peers challenge this at report stage, and in the other place the government only scraped through on this measure by 200 votes to 198. But if I believe what I am told by the Minister, it would be that the scrapping of the presumption of responsibility is entirely uncontroversial and entirely reasonable. Unfortunately, that's not the case. And it is in the wider context of the Chancellor's new settlement with financial services that this, in particular, gives us real cause for concern. Madam Deputy Speaker, we believe we need a healthy and effective banking sector that is appropriately regulated and serves the interests of the whole economy, doesn't hurt ordinary people or small and medium-sized businesses, and delivers vital investment our country needs for long-term growth. We believe the Conservative government climb down on the presumption of responsibility that it previously supported will hinder, not help, the fulfilment of this ambition. Personal responsibility is vital for the operation of our regulatory systems. This policy U-turn by the Chancellor reduces exactly the personal responsibility which the Parliamentary Commission on Banking Standards recommended in its 500-page report. Scrapping a key measure before it's even had the chance to be tested doesn't make any sense. Unless, of course, the Chancellor is just following bankers' orders. This startling and precipitous scrapping of a widely welcomed measure shows that there is a very real risk of failing to learn the lessons of the bankers' crisis. And that concern on our part goes very much wider than the presumption of responsibility, but also to the role of the Governor, the work of the FCA, and the programme of selling off, for example, RBS shares at a loss to the taxpayer. The Chancellor's whole approach says, let's get back to business as usual. But it was the bankers' business as usual that brought Britain to the brink. It was the bankers' business as usual which caused the deficit. And returning to business as usual will make another financial crisis with disastrous consequences for those we are meant to represent in this place even more likely. And that, in order to clear up any confusion on the part of the Minister, is why we are asking the Government to think again today with our reasoned amendment.
Order, before I call